Hello, thank you for joining me. My name is Kate Schilling and I'm an attorney. I work at GWAR, Greater Wisconsin Agency on Aging Resources here in Madison. And I'm pleased to talk to you today about proactive planning for older adults. I'm going to go ahead and share my screen with you so that you can see my slides as we go through them. All right. So I wanted to talk to you first about some of the myths that we hear, common myths that we hear about estate planning or even end-of-life planning. The first one is that only sick people need powers of attorney. Not true. Family members will inherit a person's debt after they pass away. That's also not true in Wisconsin. Social Security benefits will cover the cost of a person's funeral. Not usually the case. Medicare will cover long-term care needs. And only people with a lot of money need an estate plan. That's not true. And once I've drafted my documents, I'm all set. I don't need to worry about it anymore. It's usually something that people should continue to review and update as time goes on. So we're going to talk about some of those or all of these different myths and why they're not true and what you can do to make sure that you're staying on top of your planning and that it accurately reflects your wishes and desires. So first I want to talk to you about legal decision making in Wisconsin and how that works. Wisconsin's not a next of kin state or a family consent state. And I am aware that some of the surrounding states are. So for example, Illinois is a next of kin state. And by virtue of being someone's immediate family members, you can make certain medical decisions on their behalf in Illinois. That is not the case in Wisconsin. So if my spouse gets in a car accident today, just by virtue of being his spouse, I do not have authority legally to make decisions on his behalf. Neither do his parents because he's now an adult, and neither would our children. Okay, so the only way someone has authority is if he would give it to you. You have no authority for someone once they turn 18 unless they've given the authority. So just by virtue of having a familial relationship with someone doesn't change that. So you need to have legal authority to act on their behalf, and just by virtue of being a relative or a family member in Wisconsin, that doesn't grant you any decision-making authority. That usually comes as a surprise to a lot of people. So how do you get that authority? So there are a couple different ways. You can get it from the person themselves, either through a power of attorney, or maybe they designate you as their authorized representative to help maybe with, say, a Medicaid application or a Social Security application. Or if you don't get it from the person themselves, then you have to get it from a court. So that means either a guardianship while they're alive, or it could mean a personal representative or executor after they pass away. So that's how you would get authority from someone, either directly from them or from a court on their behalf. I want to talk first, just briefly, about some other advanced directives, and then we'll get into powers of attorney. But I want to be able to distinguish other advanced directives from powers of attorney because we get asked a lot about how they work together and what they do or don't do. So there is some overlap, but yet these things each have a different objective. And I want to just distinguish them for you right from the beginning. The first one is a living will, and we get asked a lot about living wills versus healthcare powers of attorney. A living will is a directive to a doctor. So you're not appointing an agent to act on your behalf, and you are not giving someone else authority. You're telling a doctor what you want to happen if certain very specific situations come up. Okay, and if one of those situations comes up, you are telling the doctor how you want that outcome to be. And so the doctor is the only one kind of empowered by this document. So there's no agent, there's no one to make choices on your behalf. Instead, it's a document that has about 5 or 6 different, very specifically outlined circumstances. And if one of those very specific circumstances comes up and you can't make a decision for yourself at the time or can't communicate that decision, it tells the doctor what you would like to happen. Now, it only is valid in those very specific circumstances. It doesn't give anyone authority to act outside of those circumstances or kind of in circumstances that don't quite fit neatly into the document itself, okay? So it's a directive to a doctor explaining what your wishes as a patient are, and there's no one given an agency authority relationship, and you're not nominating someone, so to speak, okay? You can have both a healthcare power of attorney and a living will. The healthcare power of attorney is more broad, and it's going to encompass more situations. And it's going to give an agent authority to act in situations that are outside those that are within the document themselves. So you do in the document for a healthcare power of attorney lay out some specific situations, but the agent has authority to act outside of those. That's not the case in a living will, okay? It has to be one of those 5 or 6 situations. So you can have both, or you can have one or the other. The healthcare power of attorney is generally the preferred document. Although if someone didn't have a healthcare power of attorney agent to nominate, then a living will is a great thing for them, because it's a directive to a doctor and you don't need to nominate anybody. So again, you can have both. Definitely make sure if you're just doing one, the healthcare power of attorney is usually the preferred one, but you can certainly talk to a lawyer about that. A DNR is a do not resuscitate order. This is something that is not done as part of routine estate planning documents with a lawyer or just with powers of attorney. This is something that's done with a doctor, usually later down the road, when and if a condition comes up that is determined to be terminal. You have to be a qualified patient in order to be able to be eligible to do a DNR. And a doctor has to make that determination for you. So I don't believe that I have any terminal conditions right now. I don't believe that I have any life shortening medical conditions right now. I would not be a proper candidate for a DNR, and my doctor should not allow an order for me to be a DNR because I'm not a qualified patient. I don't meet the terms of the eligibility criteria, at least not to the best of my knowledge. So only someone who meets that definition of qualified patient having a terminal health condition is going to qualify for a DNR. And again, that's something you would discuss with your doctor. And if you and your doctor agree that you meet the criteria, and if you want to be a DNR, then your doctor would put an order in the chart. You would also be required to wear a bracelet that indicates that you are a DNR. And that is the way to inform the emergency medical personnel, like an ambulance or EMT, if they show up, that you're a DNR. If you don't wear the bracelet, it's considered a revocation of the DNR status. So it's very important that you wear the bracelet. And if someone doesn't have the bracelet on, it is considered a revocation. So it's very important. The statute in Wisconsin does require someone to wear that bracelet. That's an order that goes in your medical file, and you can revoke it at any time. And so it's done with the doctor and only for terminal patients. Authorization for final disposition. Now this has to do with burial and funeral. So if I want to designate a certain person to plan my funeral when I pass away, I can nominate that person or authorize that person in this document. So I can say I want it to be my spouse or my sister or my adult child, whoever I would want it to be. I can pick someone to take care of that. This document also says what kind of things do you want at your funeral or burial. So for example, some people might have very specific religious preferences, or they might have a certain song they wanted played, or a certain ceremony, or a certain procedure, or type of celebration. And so they would put this into that document, and then that would be binding. So if someone wanted cremation versus being in a buried in a cemetery, this could go into that document. It is a document that's signed and witnessed, and that makes it valid. And I think it's equally important for someone who's considering doing one of these, not just to nominate someone, but to tell people what they are interested in having for their funeral and burial. And I think that will keep someone from having to make those choices down the road. So funeral pre-planning can be a great thing as well. But some people just like to put in, hey, I want a certain song played at my funeral, or I want a certain person to make that decision, or I want certain religious beliefs or practices followed. Now, if I don't fill out an authorization for final disposition, here is the list by statute of who makes the decisions for my funeral if I pass away, or if and when I pass away. Number one, the representative on the form. So whoever I mark on that form is number one if I have filled out the form and had it validly witnessed. If I haven't, then it goes according to this list here. So my spouse, if he survives me, my children, if they survive me, if not, my parents, if I have any surviving parents, or my siblings, and it kind of goes down the list from there. And so it goes down, if there's not a surviving spouse, it goes to the next line on the list. So by statute, this is the order of who gets to make the choice for your funeral if you haven't filled out the form. All right, so now let's talk about powers of attorney. And I want you to think of a power of attorney like a contract, okay? So you're gonna enter into this contract, and just like any other contract, once you've entered into it, it's going to be something that you don't change it unless you do a whole new contract, right? Because once you enter into a contract with, say, a company, you don't really go back and change things unless you renegotiate the contract. I think it's better for people to think of it that way, because we sometimes have people who try to, they draft a document and they have it witnessed, and so it's valid and it's great, and then they want to change something around, and so they write all over the document, and that's not to be done. That can potentially invalidate the document, or it can be considered a revocation, and usually that causes more problems. Yeah, because no one knows what the person really wanted or intended, or you do know what they wanted, but they didn't do it right. So if you're going to change your mind, you can do so at any time by drafting a new document. But a power of attorney is great because it gives you a lot of flexibility, and it makes you the person who's in charge. You pick your own agents and you decide what authority they're going to have as your agent. So it gives you a lot of control over that, and it also means that things will play out according to your wishes. All right, so the forms are available in many different places. We have a financial power of attorney and a healthcare power of attorney. So the state, Wisconsin Department of Health Services, has these forms on their website. There's a 5 wishes form that's available in various languages. I think it's a cost of $5 to download the form. Honoring Choices is an initiative in Wisconsin here, and they promote people filling out advanced directive forms. They are available in various languages as well. Private attorneys will draft powers of attorney for you as well. And so any one of these are all going to be considered valid. And sometimes people have a preference of one form or the other. And it just really depends on what your situation is. You certainly don't need an attorney to do a power of attorney form, but what you're paying for is not necessarily the document. What you're paying for is the advice and their experience and helping tailor the document to your situation and your needs. So I think it's always ideal to have an attorney, but is it absolutely necessary? No, you can do one without. I would say I do see a lot of powers of attorney that are executed wrong. That means they didn't have proper witnesses. They didn't have proper execution requirements. So sometimes there are things that make a document invalid. And that right there is a really good reason to go to an attorney, because they'll make sure your document's valid. All right, so let's talk about your healthcare power of attorney and what role the agent plays as your healthcare power of attorney. So obviously they're going to oversee your medical issues. They're going to decide to consent to surgery. They're going to perhaps admit you to a nursing home. They're going to make your treatment and care decisions. They pick the doctors you see. They might elect into hospice or discontinue hospice. They can make end-of-life choices according to your power of attorney. And they can also admit you to a nursing home. So for example, if that's the only place that you can be properly cared for, do they have the right to admit you, yes or no? We have a lot of people that say on the power of attorney form, they say, I don't want to go to a nursing home. And that's fine. Most people don't want to go to a nursing home or a skilled nursing facility. Marking yes on the form doesn't mean you want to go. It just means if that's the only place that you can be properly cared for, does your agent have authority to admit you? And if you mark yes, that means your agent has authority if that situation comes up. If you mark no, it means your agent needs to get a guardianship through the court process. And you might still have to go to a skilled nursing facility or nursing home, but it's going to take longer and be more expensive. So unfortunately, marking no there doesn't always mean you're not going to go. It just makes it a little bit more difficult. And so that's fine. I've had people say to me, well, that's okay. That's what I want. I want it to be as difficult as possible. So that's your choice. So it'll be an answer to mark yes or no. Does the agent have authority to admit you to a nursing home? All right, so let's talk about the financial power of attorney. The financial power of attorney gets to do things like manage your banking, manage insurance, file your taxes with the IRS or Department of Revenue, sign your apartment lease, maybe sign a cell phone contract, oversee business assets, sell your home, and coordinate and claims for public benefits. So any kind of health insurance you might have, if you have Medicare or Medicaid, that would be something your power of attorney for finances would do. So some people who just draft a healthcare power of attorney are really only doing half of the work that's needed, and they might still need a guardianship. And so it's really important that people do both a healthcare power of attorney and a financial power of attorney, because they need someone to be able to manage their finances, manage their insurance, and manage their assets. Now, a power of attorney has to act according to the expressed wishes of the principal. And the principal is the person who wrote the power of attorney document, the person it's about. It's only if their wishes are unknown that the agent makes his or her own choice according to what they think is in the person's best interest. So I'm going to give you an example of that. We had a case come in where there was a mother who had cancer, and she had been battling cancer for a long time. The doctor finally said, or at some point, I'm sorry, the doctor said, you know, I don't know if it makes sense to keep going and fighting this. And so the woman decided she was going to stop fighting and she was going to go off chemo. And so she enrolled in hospice. And at some point, her power of attorney for healthcare was activated. She was less and less able to make her own decisions. So her daughter became her power of attorney, and her daughter was an adult. And her daughter, when she became power of attorney, said, that's it, we're going back to chemo. We're going to try to fight this. We're going to bring all the treatment we can on board, and I don't want to do hospice anymore. The daughter can't do that because that's against the wishes of the principal. And we knew what those wishes were because mom said it. She did not want to do treatment. She did not want to continue chemo. She wanted to go on hospice. So just because the power of attorney is activated, it doesn't mean the daughter can go ahead and change things that are already in place and already happening. And because we knew what mom's wishes were, daughter has to abide by those wishes. She cannot say, I want to do this, because it's not what she wants. She has to go according to the principal's wishes, unless we don't know what those wishes are. And then it's a best interest standard. All right, so usually a power of attorney for healthcare and a power of attorney for finances, if you do them both, that's usually sufficient. And usually most people don't need to have a guardianship, or they will just have what they need with a power of attorney. And it's a best case scenario because there's no court involvement with a power of attorney, doesn't cost very much to have one. You get to decide the authority, you pick your own agent, and you get to decide you get to put your wishes in that document so that those wishes are known. But unfortunately, there are certain things a power of attorney cannot do. So even if you have one, sometimes there are things that a power of attorney agent can't do. So an agent can admit someone to a nursing home if the healthcare power of attorney says, yes, my agent has authority to admit me to a nursing home. But the problem is if someone tries to leave and they try to escape in the middle of the night, for example, sometimes with Alzheimer's or dementia, people are trying to leave the facility routinely. So if they need to be held in the facility against their will, or for example, being in a locked unit, then it needs to go to court and there needs to be court approval for that. Okay, so unfortunately, that's not something a power of attorney would be able to do. Now, again, a power of attorney for healthcare can admit someone to a nursing facility, and usually that's sufficient. But if the person is trying to leave and we have to hold them against their will, then you need a court order to keep them there. Now, you also can't change beneficiary designations typically with a power of attorney. And you can't appoint a new agent. So if you name two agents and unfortunately they're in a car accident at the same time as you, with you, then you know, no one else can name another agent. It had to be someone that was named in your document. And they usually cannot create a special needs trust unless it was stated in the document that they could create and fund a special needs trust. And there's some specific language that needs to be stated there. So for example, if someone has a beneficiary or a sibling or family member with a disability who might be on Medicaid or who might have other benefit programs, it's really important to go see a private attorney to make sure that that it wouldn't kick them off any benefits if they were to receive some money down the road. All right, so usually a power of attorney is sufficient, but sometimes there are situations where it's not. So either if someone didn't do a power of attorney, or if it's invalid, or the agents are unwilling or unable to act, or if additional authority is needed, all of those situations mean that you would need to go to court and have a guardianship. And a guardianship is a legal relationship created by the court, okay, and created by a judge. Now, there's a presumption of competency in all adults. So once you turn 18, when you're 18 and older, there's a presumption of competency. And it's only when a court finds that you're not competent that that changes. But there's a presumption for all of us. And guardianship is really only necessary when other lesser restrictive alternatives are not available. So for example, if a power of attorney is sufficient, then you're not a proper candidate for guardianship because you don't need one. Or if having a representative payee help with your bills solves your problem or solves the issue, then you don't need a guardianship, right? So if any lesser restrictive alternatives are available, then a guardianship's not proper. And just as a reminder, someone being 90 is not sufficient to say they're incompetent, or someone who uses a wheelchair for mobility alone that's not sufficient to say someone's incompetent. So just picking out a physical disability or an age, or maybe they just disagree with the decisions you would make, none of those things would qualify someone for a guardianship. So on your screen, I have the legal definition of incompetency. And this is kind of tricky. So incompetency is a standard for guardianship, and it's a legal standard that a judge or a jury determine you meet to qualify for a guardianship, okay? Now, there's 4 bullet points, and all of those combined, that's the standard for a guardianship, okay? And the standard for guardianship, again, is incompetency. The very first bullet point on your screen is the standard for incapacity. Incapacity is a medical standard, and 2 doctors, or a doctor and a psychologist, or a doctor and a physician's assistant nurse practitioner, would decide if your powers of attorney would be activated based on incapacity. So that's kind of tricky. So powers of attorney are activated upon incapacity, and the standard for incapacity is a medical standard. It's the first bullet point here: inability to receive, evaluate, and communicate decisions. But a guardianship is more than that, and it's all 4 bullet points here on the screen. And the standard for guardianship is incompetency, which is a legal standard that only a judge or a jury can make. Okay? All right, so that's a little tricky. All right, so guardianship is a court process. Powers of attorney are usually not in the court process unless there's a problem or something's gone wrong. Guardianship is entirely a court process. So right from the start, a court will be overseeing it. And it'll take 1 to 3 months to get started, depending on what county you're in. Milwaukee County obviously has a little bit longer backlog than some of the other counties. So it really kind of depends. And again, it's a legal standard of incompetency, and it's made by a judge or a jury. And then it's a best interest standard. The judge is the one who determines who the guardian will be, and the judge is the one who determines what authority that guardian will have. So there are 2 types of guardianships. There's a temporary that usually lasts 60 days, but can be extended another 60 days. And then there's what we call the permanent, and the permanent one is in place until someone affirmatively challenges it or removes it. So it's typically in place longer term. All right, now for guardianship, we have 2 different kinds of guardianship. We have guardian of person and guardian of estate. Now, guardian of person is in charge of medical decisions, where the person lives, finding them appropriate supports. Also, I wrote down DVR, which is Division of Vocational Rehab, if someone needs help finding a job or with job placements. Now, guardian of estate is the one who's going to pay your bills, manage your insurance, sign that lease or a cell phone contract perhaps, and also a guardian of estate is the one who helps apply for public benefits or manage public benefits. So Medicare, Medicaid, health insurance, okay? All right, so regardless of whether it's a guardianship or a power of attorney, both of them, the authority ends at death. No matter what, the authority ends at death. And most banks will not accept checks that are written by either a guardian or power of attorney after the person's date of death. So that's really important. Usually when you're a power of attorney or a guardian, after the person passes away, you essentially do a final accounting, and you would notify Social Security that the person's passed. And at that point, a personal representative, or what other states call executor, would take over. All right, now I stole this from Honoring Choices, which is an advanced directives movement here in Wisconsin, and I think it's really great. People say, oh, I've done my powers of attorney, I'm good for the rest of my life. Nope. I'm glad they've been done, but you have to review them if any of the 4 Ds occur. So death. If any of the named agents in your power of attorney pass away, it's a good time to update or review that power of attorney document. Likewise, if you get a divorce, in Wisconsin, the law assumes you intended to update your documents and forgot. So the law will actually invalidate that reference to a former spouse, but that means you need to pick someone else and get your documents updated. So that's very important. Decade. If it's been more than 10 years and you haven't updated or reviewed your documents, it's a good time to do that. Or diagnosis. If you have a new health diagnosis, any kind of diagnosis, it's a good time to review those documents and make sure they say exactly what you would want them to say. All right, we get a lot of questions about wills or trusts, and so I wanted to just touch on that briefly. And a will directs where your assets are going to go upon your death. Okay, so who are the beneficiaries and in what order do they get paid? Do people get paid certain amounts of money? Are people going to get what we call the residue, whatever's left over? And how is it going to be divided? A person can do a will, and that will be divided through a probate action in court, or they can do a trust, and that's typically administered privately according to the terms of the trust. And then you'd either nominate a personal representative through your will, which again is an executor, or a trustee to administer the terms of the trust according to how it's written. Now, if a person doesn't have either a will or a trust, then the court determines how things are going to be paid out according to state statute. Okay, so then there's, just like with the funeral designation of who makes your funeral and burial choices, there's a list in the statute that says, here's who things go to if you don't have a will. And the court and the state make assumptions based on where they think you would most likely want things to go, but it may or may not be accurate based on your personal situation. Now, a will cannot override a beneficiary designation. So let's talk about that a little bit. or the titling of deeds, okay? So let's talk about that. Beneficiary designations are very common on retirement assets, so 401k, 403b, IRA, also life insurance, right? I've been working at this job for 8 years. And when I first started, they asked me to fill out my beneficiary designations, who I'd want on my life insurance policy, okay? Now, most places don't ask you to revisit that and check that every year, right? They do ask you to look at your health insurance and say, is this still what you want for next year? And people do. But a lot of employers don't make it a point to say, hey, have you checked your beneficiary designations recently? That is definitely a good thing to do. So I recommend that people do that once in a while or every few years, because some people have been working at the same job for 20 years and a lot in their life may have changed. They may have gotten divorced. Their minor children may have now become adults. They may have had more children. You know, there are a lot of things that can happen in someone's life. So we encourage people to check your beneficiary designations, and if they're not who you want them to be or what they should say, you can always update those at any time. But oftentimes people aren't prompted to look at those, and so sometimes that's neglected. And the beneficiary designations are a contract, so it pays out according to who's listed as a beneficiary, and whatever your will says, it doesn't have any bearing whatsoever on your beneficiary designations. That's why it's so important to make sure that they're correct, because your will not have any control over it. Some CDs, bonds, stocks, a lot of those have beneficiary designations. Annuities typically have a beneficiary designation, and sometimes bank accounts have a pay on death designation. So that's important as well. All right, so here are some reasons to meet with an attorney. Is it required? No, but here are some really good reasons that come up often where I think people should strongly consider meeting with an attorney. Number one, to draft or update a will, power of attorney, or a trust. Marital property agreements, determining in a marriage what's yours is yours or what's mine is mine, or do we share everything? So going through and determining how things are owned, discussing titling of assets, if long-term care Medicaid is needed in the future, blended families, second marriages, or unmarried couples. So for example, I come from a situation where it was a second marriage, and my dad had 4 kids of his own, and my stepmom had 2 kids of her own. They had no kids together. So how are things going to get divided up once they've been married for several years and they're now commingling money? So those are really important situations to consult with a lawyer. Also, if you need to draft a special needs trust for any family members with disabilities, it's highly recommended that you would seek legal counsel for that. I do get asked about Social Security benefits and how much Social Security will pay towards someone's funeral. And right now, the amount is $255 for a death benefit. It's a one-time benefit. And so people may wrongly assume that Social Security covers the cost of a person's funeral, but typically this will only cover the cost of the obituary and maybe not even that. So just a heads up that for the worker benefit for Social Security is $255. All right. But there are other derivative benefits. So there are widow's benefits, and this is if someone who worked and paid into Social Security for a good portion of their life, if they pass away and they leave a surviving spouse. So that surviving spouse is going to get that one-time death benefit of $255. Widow benefits will start at age 60, possibly even age 50 if the person's disabled. And depending on what age the primary worker retired and at what age the widow retires, they can get up to 100% of the widow's benefit. It is going to be reduced about 1/3 for early retirement. And so that is something important to keep in mind. Also, widow benefits will stop if the person remarries prior to age 60. And I did have that happen once. I had someone who got married. She had been widowed for a long time. She got remarried 2 months before she turned age 60. And sadly, she lost her widow's benefit. She was unaware of the rule. So So she lost that benefit going forward. Now there are also what we call young mother benefits if someone's caring for a child that's under 16 or caring for a child that's disabled after the other spouse has passed away. So there are other derivative benefits as well. We get asked a lot about spousal benefits. And with spousal benefits, it's half of the worker's benefit or their own full benefit, the spouse's full benefit, whichever one is greater. So you don't get both, you get either one or the other. So you either get your own full benefit or you get half of your spouse's benefit if that's larger than your full benefit, okay? And the criteria is different depending on if you're married or if you're divorced. And if you're married, Social Security says in order to get the spousal benefit, you have to be age 62 or older, and your spouse has to be also receiving benefits. So that means either receiving early retirement benefits at 62 or later, or on SSDI, which is Social Security disability. And they have to be drawing those benefits. So they can't just be eligible, they have to be actively drawing those benefits for you to qualify as a spouse. So for example, I'll use my parents. My parents are divorced, but they were married for 19 years. And my mom stayed home and raised the children, and she didn't work out of the house very much. My dad was the primary earner, working sometimes up to 3 jobs to support the family. And so he has a significantly larger work record through Social Security. But since he was married to my mom for more than 10 years, my mom can qualify as a divorced spouse under my dad's earnings record, okay? So this is under the divorce category. So they were married for 19 years, so they met the 10-year requirement. They've been divorced at least 2 years. My mom has not remarried. My dad did remarry, but my mom has not. And in the situation of a divorce, the primary working spouse need not have been drawing benefits for the spouse spouse to get the spousal benefit. And Social Security figured out that sometimes when couples are divorced, they don't do the nicest things to each other. And they figured out that sometimes one spouse would intentionally not take benefits so the other one couldn't get it off their record if they were divorced. So Social Security had to go in and change that really quickly because now it does not require the primary spouse be drawing benefits in order for an ex-spouse to be receiving a spousal benefit. So for example, my mom can receive half of my dad's Social Security benefit, even if my dad's not drawing his own. But if they were married, my dad would have to be drawing his own benefit for my mom to qualify for the half spousal benefit. But they're divorced, they've been divorced for a long time. Now what's really important is this is a derivative benefit. This does not reduce the primary worker's benefit at all. So my mom being able to draw half of the spousal benefit from my dad's work record does not reduce my dad's benefit at all, right? So my dad's benefit is the same no matter whether or not my mom draws at all on his earnings record. My dad's record doesn't change at all. Spousal benefit is an extra additional benefit that's paid out on top of the worker's benefit. All right. Long-term care. So the average cost of nursing home care right now in the state of Wisconsin is just a little bit over $8,700 per month. That's very expensive. And so unfortunately, people who need long-term care in a nursing facility run out of money very quickly, and as would most average people in the state of Wisconsin. That's very expensive. So we have a lot of people that come to us talking about how do we get coverage for long-term care. And I want to talk to you about this. And first we have to be able to know the difference between Medicare and Medicaid. So Medicare is the red, white, and blue card that comes in the mail when people turn 65 or perhaps earlier based on if you qualified for Social Security disability. There's really no income or asset test whatsoever with Medicare. It's just based on age, or if you have a qualifying disability, you can sometimes get it sooner. Now, by contrast, Medicaid is on the other half of your screen. Medicaid is has very strict income and asset limits. You have to continue to qualify each month in order to be eligible going forward. And people with disabilities or certain other classes of people, categories I should say, of people can qualify. So for example, children, women that are pregnant, people with a disability, or sometimes childless adults without a disability. So there are certain kind of categories of people that will qualify. But for the most part, you typically have very strict income and asset requirements, and you have to have a disability. All right, so Medicare has 4 parts. We have our A, B, C, and D. A is our inpatient and skilled nursing facility stay and hospital coverage. And Part B is our outpatient medical and outpatient clinic, for example, or x-rays or lab work or outpatient physical therapy and durable medical equipment used in the home. Part C is privatizing Advantage plans. So that's privatizing Medicare, and this is fully optional. Part D is drug coverage. And if you don't choose a Part C plan, then your other option is a Medigap plan or a Medicare supplement. So those are kind of the parts of Medicare. Medicare doesn't provide long-term coverage. So it will never pay for what we call custodial care in a skilled nursing facility or nursing home. And by custodial care, I mean, for example, someone with dementia or Alzheimer's who is needing assistance with activities of daily living, like toileting, bathing, showering, eating, and they're not really doing any like active rehabilitation, okay? Whereas someone who falls in the driveway and breaks a hip, they might have a broken bone, they might need surgery, and then they would go to a skilled nursing facility to get rehab and to kind of get back to where they started from. So Medicare will cover that situation if you need that active rehabilitation. So you have to have occupational therapy, physical therapy, or speech therapy approximately 5 days a week or more in order for Medicare to cover it. So it has to be that active rehab. And typically Medicare requires a 3-day inpatient hospital stay as well. All right, now Medicaid, by contrast, is a little bit more comprehensive. So Medicaid, remember, it has those income and asset limits. You have to either have a disability or be age 65. It will cover long-term care, and it will cover even custodial care, which again is someone needing help with activities of daily living like walking, toileting, bathing, showering, eating, and Medicaid can also sometimes be retroactive. So there are some wonderful things about Medicaid. It works really well with, like, it'll coordinate with Medicare really well. The two will coordinate benefits together well. It's very comprehensive. It covers long-term care needs. You can apply you can apply any time, and sometimes it's also retroactive. Now, a couple things that people do not like as much about Medicaid is there are divestment penalties. People are screened to see, did they make any divestments? Did they give any money away? Did they transfer anything for less than fair market value? We have a look back period for that. Also estate recovery, which we'll talk about. And again, there are really strict income and asset criteria that people have to continue to meet month by month going forward. And by long-term care Medicaid, what I'm referring to is 2 different kinds of coverage, either coverage in the community where people come into your home and they help you and make sure that you are living independently and can stay living in your home as long as possible. So that's family care and IRIS. Some counties have PACE or partnership. And again, this is in your own home or an assisted living facility. Otherwise, Medicaid will also pay for long-term care in a nursing home or institution like a skilled nursing facility. All right. So we get asked a lot about Medicaid spend downs, and this is just very general, but typically a single person has a $2,000 asset limit for Medicaid, and that's $2,000 in countable assets. And married couples can have at least $50,000 and oftentimes more in countable assets. So here's just a little bit about how that goes. Yes, there is sometimes a spend down, but it's important to understand what assets are exempt and what assets are going to be counted. So Medicaid does not count your house or your one car between you as a married couple, one car. Burial funds, as long as they're set up correctly, they will be exempt. Your personal belongings, your household furnishings, burial assets, And also the IRA or retirement account of the community spouse are not counted. Now, if you own more than one piece of property or land, that will be usually counted. Your bank accounts count, life insurance typically counts, other vehicles, if you have a second car, third car, fourth car, or real estate that's not connected to your house. So other things will count, but a lot of people, for a lot of people, their house is their most important or most expensive asset, and that's exempt. Okay. So again, this is just kind of a generalization, but just to give you a little bit of information. Also, Medicaid doesn't want what we call the community spouse, the person who's not on Medicaid, the other spouse, to be completely impoverished. And so they do allow some income and asset shifting to keep that person above water, so to speak, so that they're not completely impoverished and, losing the home to foreclosure or, having to declare bankruptcy. So those are really significant things, and we try to help keep that spouse afloat as much as we can, and we try to divert income to the spouse who's living in the community still. Now, there is a cost share patient liability when someone's on Medicaid. When they're on the long-term care Medicaid benefit, they have to pay towards their cost of care every single month. Sometimes they can do income transfers to a spouse instead of paying for their patient liability or cost share each month. And so again, each situation is different, but generally speaking, people are paying towards the cost of their care. If someone is single and they're in a nursing home, they're not married, most of their income is going to go towards their cost of care in the nursing home. They are going to get $45 to keep for themselves, and they will get offsets for out-of-pocket medical expenses and a couple other things, but it's not a lot of money to live on. And so that's why it can be really nice to have a special needs trust set up, or, if there's any other assets out there. It's really hard to live on $45 a month. All right, so divestments. Divestment is transferring a gift, money, property for less than fair market value. Okay, and sometimes it's pretty black and white where it's a gift, and sometimes it's a little bit trickier. So whenever someone applies for Medicaid, they're going to look back 5 years from the date of application to see if any gifting or transfers were done during that time period. And if they are, then that can cause a divestment penalty and render the person ineligible for Medicaid for a period of time. And you're asking, how would they know? Well, they have automatic online records where they can look through bank records online to kind of find out someone's balance and sometimes other things. They can ask you to produce monthly bank statements or online banking statements. And so they will ask for verification of any bank transfers or checks above, $100 or something. So it is a pretty rigorous process to get started if anything in the verification process looks a little bit suspicious. All right, so again, some of these are really black and white, like a gift. If someone gives away $2,000 to each of their grandkids, then that's pretty clear that that's a gift. But also it can be something like adding someone's name to the deed of their house. So if I'm a single person, and let's say I own my house all by myself as a single woman, and let's say I add my sister's name to the title of my house. I've just given her half of an interest in my home, and she didn't pay anything for that. Okay, so that's a divestment because she didn't pay anything, and I've given her essentially half the value of my home. So adding someone's name to a deed, sometimes putting someone on as a joint checking account holder at a bank. It's okay to add them, but if they take any money out, that's going to be a divestment, and that becomes a problem oftentimes. So adding someone's name as a joint bank account holder is not something I'm fond of. I see it be a problem more often than not. Always better to use a power of attorney document if you want someone to have authority or control on a bank account. Sometimes people will pay a bill for someone else. So I've had some clients where they had adult children that were having financial hardship and they tried to bail out their children. So I had one where her son was going to have his home foreclosed upon him. And so the mom, the older woman, paid about $10,000 to the bank so that her son's mortgage wouldn't be foreclosed on, because son had gotten really behind on his mortgage payments. Well, that's not a bill mom was legally required to pay. So because she paid it on behalf of her son and her name wasn't on that mortgage, that was a divestment. So even though she was, being nice, trying to help out her son, that actually counted as a divestment against her because she was not legally obligated to pay it. I had a different couple a few years later who their son was about to declare bankruptcy because he had a lot of bills, credit card bills, and a couple other loans, and he was going to declare bankruptcy. The parents decided to bail out their adult son, and they paid off his bills to the tune of about $25,000, so he didn't have to declare bankruptcy. And even though it was very nice of them and they felt like a moral obligation, they said, to help him, unfortunately, that was a divestment and it was held against them when they later needed to apply for Medicaid. So those types of things can come up later down the road if Medicaid becomes an issue. All right, so here's just my warning that when a person is helping out a family member, Medicaid assumes that you're doing it out of the goodness of your heart and that you're doing it, it's presumed to be gratuitous, so that it's presumed that you're not expecting payment. And that in order, if you are expecting payment, there has to be a notarized contract in place prior to any payments being made, okay? So for example, when I was growing up, my mom would take us to my great-grandmother's house every Monday, and my mom would mow her lawn. And so we would go to grandma's, we'd get Kentucky Fried Chicken and Tin Roof Sundae ice cream, and we would go to my great-grandma's, and my mom would mow her lawn and make sure she was doing okay, help her pay any bills, and we would kind of all sit there as kids and hang out and, spend time with my great-grandma. But my mom was really making sure she was doing all right, because she was needing a lot of care in the home, and they were trying to have people stop in almost every day to make sure she was doing all right. Now, did my mom expect to get paid? No way. It was 45 minutes of a drive each way to get there and then to get back, but my mom didn't expect to get paid. There are certain circumstances, though, where family members are putting in a lot of time as caregivers, and sometimes fairly there is an expectation of payment, but Medicaid says you can't expect payment unless there was a contract in place that was signed and notarized before the payments were made. And so all transactions with family members are really highly scrutinized. And so Medicaid's going to call this a divestment. And so I just want to make sure people are aware of that. There are definitely circumstances that warrant family members being paid, but the expectation is that there's a caregiver contract in place. So that would be my warning to you. All right, so if someone gives away money, how do you calculate a divestment penalty? Well, here's what we do. We take the amount of money that was given away, so in this example, $75,000, and we divide it by the average cost per day of nursing home care in the state of Wisconsin, which right now is $287.29. And then we get a number of days that you'd be ineligible. So this person would be ineligible for Medicaid for 261 days. So about 2/3 of the year. And it does go according to days. All right. In the past, people could cure a divestment penalty by giving back some or half or a portion of the money, and that rule's gone away. So now the only way to cure a divestment penalty is to get the money or the property or whatever the asset is back in full. Partial cures are not allowed. You have to get the full amount of money back from the person. And I just wanted to make note that there are some divestment exceptions. Transferring money or property to a disabled child of any age, whether they're a minor or an adult, that's not a divestment because that person is deemed to need the money as well. And so, for example, if I have a disabled child, if I decide to leave my house to him at some point in my life, that's not a divestment for me if I have a disabled child. Okay. Also, if someone lives in a home with their parent for 2 years or more and provides care to that parent and delays the admission to a nursing home, that is one of the divestment exceptions as well. The parent can transfer or deed the house to them, and that's not a divestment. Now there might be other reasons for doing it or for not for doing that. So that's something to discuss with a private attorney, and it needs to go from the person's house directly to a nursing home with no stops in between. But that's something to be aware of as well. We do see a lot of times where someone lives with their parents for at least 2 years and they provide care and they delay that nursing home admission. So that requires a signed statement from like a doctor, social worker, neighbor. But those are really important situations to be aware of. All right, so estate recovery. Estate recovery, the rules changed in Wisconsin in 2013 and 2014. And some assets were grandfathered, some were not. For the most part, though, we have become more liberal with estate recovery here in Wisconsin. There's a lot more estate recovery than there used to be. In the past, it used to just be only assets that went through probate were subject to estate recovery. That's not the case anymore. So that changed in 2014. Now it's essentially all assets, including life estates and life insurance, can be subject to estate recovery. So what is estate recovery? Well, estate recovery is part of the Medicaid program that comes in. It's for long-term care Medicaid for people over 55. If they were on long-term care Medicaid and that paid for things for them, say like nursing home care or family care or IRIS care for them in their home or in the community, then if that person has any assets left when they pass away, estate recovery tries to recoup some of the money that it paid out during the person's lifetime. So there are certain exceptions that estate recovery cannot come in, but for the most part, it's gotten a little bit more broad, and it's always best to check those rules against your specific situation. So like, for example, if someone leaves a surviving spouse, they have to wait until that surviving spouse passes away, and then they can recover. And they can recover at that point half of essentially what's left. So there are, some people are drafting marital property agreements, some people are consulting with an attorney to determine how to best go around this. Sadly, I have seen an increased number of divorces recently with older adults, and so I hope it's not from this, but I think we're still kind of finding out what's happened after that change in the law. I do want to just tell you, be really careful if there's an estate recovery issue. Make sure you save your receipts for funeral or burial, and make sure you act quickly, because a lot of the notices have a 30-day or 20-day or 45-day time frame. So it's really important that you respond to the notices, or that you contact someone at the ADRC for some help, or a private attorney. These are really important situations. All right, and just lastly, I wanted to go through some resources with you. Here at GWAR, we have a guardianship support center, and we have an attorney here who will answer your questions about guardianship and powers of attorney, do not resuscitate orders, living wills, authorization for final disposition, a lot of the things that we talked about today. So we don't do any representation in this program, but we will give you legal information. We'll tell you what the statutes say, or what the court forms say, or what typical procedure would be. We also have a quarterly newsletter that I would encourage you to subscribe to, and you can do that on our website. So here is a link to our website. It's gwaar.org/GSC, or you can email us at guardian@gwar.org and say, hey, I'd like to be on your newsletter. Please sign me up. You can call us or email us at this contact information with any questions. And if you do call, just note that you do have to leave a voicemail, and no one answers that phone live. We respond to questions in the order that, or we respond to calls in the order that the calls come in and are received, but we typically cannot get to all of them every day. And so there's usually about a 48-hour lag there. So we'll return your call within just a couple days. All right, Board on Aging and Long-Term Care is a wonderful program. They have an ombudsman program that helps people if they're having rights issues, or if they're having any kind of conflict within an assisted living facility, or a skilled nursing facility, or a nursing home, or with their family care or IRIS waivers with the Medicaid program. They also give consultation to people with Medicare and also with Medicare Part D, and they have a helpline for that. Disability Rights Wisconsin also has a Family Care and Iris Ombudsman program, and they have an SSI Managed Care Ombudsman program, and they're the protection and advocacy agency for people within the state, for adults within the state. So I have their information on the screen that you can contact them. They also have a disability voting rights helpline because it is election year, so please take note of that. If you're looking to call Medicare, the number to do so is 1-800-MEDICARE, and they're open 24 hours a day, 7 days a week. They usually do close for Thanksgiving, but otherwise they're essentially open. And just a note that if you're on Medicare, Medicare open enrollment for Medicare Part D and Advantage plans is October 15th through December 7th. Medicaid Forward Health, I have their contact information on here, and also Senior Care, the Wisconsin drug program for people 65 and older. If you're looking to hire a private attorney, there are 2 different resources I would recommend. Number one, National Academy of Elder Law Attorneys. We call it NALA for short. You can type in your zip code and it will spit out attorneys that are close to you in your area that are members of the National Academy of Elder Law Attorneys. Or you can use our state bar referral and information service, and I have the phone number for that listed here as well. So thank you very much for listening. That's all I have for you today, but I do want to let you know that the code word for today's presentation is pennies. The code word is pennies. All right, thank you so much. I appreciate it. Have a great rest of your day.